Okay, kids, it's time for another lesson from Internet lawyer Mark Stevens. Today, we're going to cover direct personal knowledge. Stevens talks about this an awful lot, and he talks about it an awful lot incorrectly.
Points that we're looking for here is evidence proving their claim that just because you're physically in Washington that the Constitution and Code apply. The other thing is we
Yeah.
need to know if the witness they're calling has personal knowledge of evidence proving that the Constitution and Code apply. Because again, I have to keep repeating this. You have to have personal knowledge of the matters you're testifying to. If the police officer is making legal determinations that the laws apply and you violated them, which is why they're calling the cop, then he has to have personal knowledge of that. So that's what the two main things we're focusing on when we're talking with the prosecutor. And that is your opportunity to do some serious damage control, because you'll be able to get his own statements that he doesn't have the evidence, or he'll lie and say that the evidence is in the ticket.
Yeah.
And so you'll be able to use that against them.
So going into pretrials, I'm just going to bring up all the evidence that I have against them. I'm not really sure how to go about fighting this in pretrials. I keep pushing the issue. I'm going to keep pushing the issue of jurisdiction and prima facie, but other than that,
But that's what
should I
that's what
prepare
I'm saying.
myself with evidence and other things of the sort?
All you need to the only thing you need to show is bring maybe the ticket, because that's all they have against you. And so you can ask the prosecutor, where on this ticket or what on this ticket is evidence proving that just because I'm physically in Washington, your laws apply to me? What do you, it's all written down. And so when it's that specific and it's something here that could be cited very easily, then he might turn around and say, I don't have to do that. And I would say, oh, excuse me, let me see if I understand you correctly. You can make a legal claim against me and you don't need any evidence. Really? And exactly what kind of relationship do you have with the judge that you're allowed to get away with that?
Yeah.
And then you ask him, okay, so since you get to argue without evidence, you can make claims against me without evidence. Do I get to make claims against you without evidence?
Okay.
Okay, and then when he says absolutely not, I would definitely urge sanctions against you. Well, then why don't you? I said, do you think that's fair that you can make claims against me without evidence, but it's sanctionable against me if I do that? Do you think that's fair? And then say, why does again push? I like to do this. Say, what kind of relationship do you have with this judge where you can get away with that, but I can't?
Yeah. Okay.
See, and this is how the pretrial should be. You should be pounding away.
Whoa! Stevens really gets all excited and emotional and animated when his spoonerism is challenged, doesn't he? Kind of reminds you of a evangelical preacher preaching to his flock. Well, there's a lot to unpack from that rant, but we're going to focus in on the direct personal knowledge part in this series. Now there it is. There's Rule 602 that Stevens is always talking about and always explaining incorrectly. Stevens ignores the second sentence and then tries to make the cop an expert witness per Rule 703. For some reason, Stevens thinks that a cop needs to prove the law applies, which would be a question for an expert witness, not an eyewitness. Now, what can a cop testify to that he has direct personal knowledge of? The cop, like any witness, is only competent to answer questions about things that he has direct personal knowledge of, such as time, place, conditions, activity, and what he saw, heard, and experienced. The scope of his testimony is limited to those things. Just like any eyewitness, the cop is not an expert on law and is not competent to answer questions of law such as applicability, because that is beyond his scope of knowledge. Therefore, the judge would limit the cop's testimony and answers to only those questions within the cop's scope of knowledge. In other words, what the cop was competent to answer. This in no way would impeach the cop's prior testimony or be the basis to strike all of his testimony. Limiting witness testimony to the scope of their knowledge is not denying cross-examination, no matter what the internet lawyer Stevens may claim. How does a cop or any witness make a legal determination that the law applies when they see a crime and make an allegation of a violation of a law? A legal determination can be made by anyone. Why? Because a legal determination is simply based on the knowledge and belief of the witness held at the time. For example, let's say you see what you think is a crime in progress. You pull your personal concealed weapon and hold the perp at gunpoint until a cop arrives. You would never be asked to prove that the law applies to the perp to justify your actions. And neither would the cop. Why? Because you simply made a determination based on your knowledge at the time that the law was applicable. It would be up to the perp to prove it didn't. Read the slide again. That's where Stevens misrepresents the facts. The question of applicability of the law requires a legal conclusion from an expert of law under Rule 703. Otherwise, it would be a political question about the government's power, as I've previously explained. No witness can make a legal conclusion. Only the judge. A legal conclusion is final and means that all of the evidence has been presented and the judge concludes, based on the evidence and relevant law, which party has met their burden. Simple, huh? Except when Stevens applies his gibberish, conflating legal determination and legal conclusion. Therefore, it is not prosecutorial or judicial misconduct of denying cross-examination when the judge limits the cop's testimony to the scope of his direct personal knowledge and not allow him to make a legal conclusion of applicability. Stevens is totally misleading the caller either by dishonest deception or ignorance. Both are detrimental to his victims. It appears Stevens is misleading the caller in order to sell a worthless motion about prosecutorial or judicial willful misconduct. An internet lawyer tactic. You got that, Stevens?
Yeah, okay, yeah.